Good afternoon, everybody. Welcome, coming along. I'm just going to give it a couple of moments until we let everybody filter in. We've got quite a lot registered today, so we'll give everybody a chance to sit down with their cup of tea, and then we'll do some intros and get started with today's session. Thank you for coming. For those that have already signed in so far, today's session will be recorded, and you'll be able to get access to that recording afterwards as well in our replay library, but I'll cover all of that in the follow-up email. So the chat function will be available for everybody that is coming in today, so feel free to say hi. I'll be checking stuff in the chat box as well whilst we're going through the session and just monitoring it that way. Okay, I'm just going to get started now. Anybody that comes in, that's totally fine. So, welcome everyone, and thank you for coming along to today's specialist session with Darwin Gray. But before we begin, I want to take just a moment to acknowledge something every people professional carries: emotional labour. So many of you spend your day supporting others, holding those difficult conversations and staying steady through challenges. And that unseen load can build up. That's why we deliver emotional labour sessions. They're confidential, they're therapist-led spaces for you to pause, reflect and recharge. And they're designed to reduce burnout, strengthen boundaries and help you stay strong while you support everybody else. I'll include more about that and those sessions in my resources email afterwards. So we're really pleased to be joined today by our speakers from Darwin Gray, Owen John and Rachel Ford-Evans. Now, Owen brings extensive experience in defending complex, high-value employment tribunal claims, including several high-profile discrimination and unfair dismissal cases. He's also been instrumental in developing accessible legal services in Wales and is a regular contributor on TV and radio on employment law matters. Rachel is praised by her clients for excellent service and communication. She has a broad expertise across employment tribunal claims, data protection, compliance and governance, particularly within charities and housing associations, which I know that we've got a few of you today. So I'm now going to hand over to our speakers to get started on today's session.
Good morning, everybody. Thank you very much for the lovely introduction, Tom, and thank you for the opportunity to present to you this morning. Thank you, everybody, for tuning in as well. Our session is on changes to employment law, and as Tom has rightly pointed out, it's being presented by myself and Rachel. We're both partners of the employment team at Darwin Gray, full service law firm, and we sit in the employment law team. This is a bit of a whistle-stop tour, so we are going to absolutely fly through these slides, but we are more than happy to answer questions at the end. If you want to pop any questions in the chat, we'll pick them up at the end, or both of us are more than happy to stick around. I understand you've probably got busy days to get on with, but if you want to ask anything, we're more than happy to just hang around for a good while afterwards, and we'll also share the slides. So the Employment Rights Bill, there's been a lot spoken about the Employment Rights Bill, but we are still in a little bit of uncertainty land with it. The Employment Rights Bill was the brainchild of the Labour government manifesto, and they were elected off the back of that manifesto. And the bill aims to, and I will quote from the second bullet point there, to modernise employment law, strengthen worker protection and promote fairness in the workplace, or at least that's what they say. It's currently awaiting royal assent, and there is a game of ping pong happening at the moment between the Commons and the House of Lords, where the House of Lords are trying to water down some of the more radical changes, such as day one unfair dismissal rights, which we'll actually start with in a minute. That game of ping pong is ongoing. The government will get its own way in the end. They will win. And we are expecting these changes to come in across 26 and 2027. Some more dramatic changes towards the 2027 date, but some changes, and we'll mention these coming in as soon as April 2026. Rachel, if you flick the slides, there's an awful lot going on with the Employment Rights Bill. There's a lot to get your heads around, and we are going to skim the surface of these topics, or most of these topics. Some of them are more relevant than others, but they will affect you all in some way. So I'll pass over to Rachel to start us off with the one that's on the left-hand side there, about midway up, which is day one unfair dismissal rights.
Thanks, Owen, and thank you very much to Tom as well for that very kind introduction. So, as Owen said, loads to get through today. So we're just going to spend a couple of minutes on each of the main changes that we're going to be summarising from the Employment Rights Bill as we know it at the moment. Starting with the real flagship policy under the bill, and the one that you've probably heard the most about, and because it's been in the news a lot, which is an overhaul of the right to bring claims for unfair dismissal. So just to remind you, or to let you know if you don't know already, how this works at the moment. In the UK, for an employee to be eligible to bring a claim for unfair dismissal, if they're dismissed by their employer because of redundancy or misconduct or capability, something like that, they've got to have been employed by their employer for 2 years continuously. Otherwise, they're not going to be eligible to bring that claim, and so they can be safely dismissed in that first 2 years, unless it's for a discriminatory reason, it arises out of blowing the whistle or pregnancy or something like that. That is going to completely change now under the Employment Rights Bill, and so this is being called a day one right for everybody not to be unfairly dismissed in the future. And that's actually a huge change. So in the last sort of 50 years odd, in the UK, there's always been at least some qualifying period for unfair dismissal of at least 6 months, and it's kind of flip-flopped between 6 months a year and 2 years over the decades. So making it a day one right is a huge change. It will massively increase the number of employees who have this eligibility in the UK, and it will ultimately increase the number of Employment Tribunal claims that we see. But it's not completely as black and white as that, because what the government has said is that there will be an initial period of employment. Currently, that's said to be 9 months, and I think that's where we'll end up as well, during which a slightly lighter touch process can be followed by employers who want to dismiss somebody for conduct or capability. So a reason that relates to the employee personally. So rather than a full bells and whistles disciplinary procedure or capability procedure during those first 9 months, employers will be able to get away with following a slightly slimmed down, lighter procedure if they need to dismiss somebody for with shorter service for one of those reasons. But it's important to understand that that's not going to apply to redundancies. So for those people that you may need to make redundant for a business reason during their first 2 years of employment, they will now need to be treated exactly the same as everybody else who's got over 2 years service in the UK. So it is going to be a massive change. There are a lot of employers out there who currently treat people who've got less than 2 years service very differently to those who've got more. And so those employers are really going to need to sit up, tighten up their policies and procedures and make sure that they do everything properly from day one. So just a couple of quick top tips for employers in preparing for this change. First of all, as I said, your procedures are going to be key, so you need to make sure you know what you're doing. If you're planning on or thinking about dismissing somebody because you need to restructure, or you're concerned about their performance, or they've committed misconduct, you need to be very clear on what procedure you will follow in that situation and take advice on that if you need to. The other thing we would say is that this is going to make recruitment even more important. So getting the right person in place from the start is going to be really, really important, because that's going to reduce the chance that you need to consider making dismissals in the first place. So getting recruitment right, again, is going to be absolutely key when this change comes into force, which we expect to be 2027. And the other thing to say is probationary policy. So lots of contracts of employment and policy say that you can be dismissed at any time during your probation period, just on 1 week's notice if the employer thinks you're not working out. That's not going to cut it anymore in the Employment Rights Bill. So that's also going to be something that needs to be looked at, because those people will have more rights to have a proper process followed with them if they are dismissed during their probation period. So that's the first key change, unfair dismissal. As Owen said, this is flip-flopping a bit between the Lords and the Commons at the moment, but we're pretty sure that this is where we're going to end up. The Lords keeps trying to water it down, the Commons keep sending it back, and I think we will get to this point eventually, and this will come into force in 2027. The next change then relates to workers on 0-hour contracts. So these aren't people who are fully blown employees with continuous service. These are casual workers or 0-hour workers who don't have the right to a minimum number of hours under their employment contract. And based on the data that we have at the moment, we think that there are over 1 million people in the UK who work under that kind of contract. That can obviously bring flexibility for both parties, but it can also lead to exploitation of workers. And that's what the government is trying to clamp down on here. So the proposal to change here is to offer all 0-hours workers the right to be offered guaranteed hours after a certain period that they've carried out work for the employer. And that's currently set at 12 weeks, so expect it to be 12 weeks. So that means that after a casual worker has been on the books for 12 weeks and they've worked whatever hours that might be during that period, the employer will have to look at those hours, average them out, and make an offer to that worker of guaranteed minimum number of hours going forward from that point. Now, that will be the worker's choice as to whether they want to say yes or no to that. But the way the bill is drafted at the moment is that the employer will have to keep making that offer every so often. Again, we think every 12 weeks to make sure that that offer is still available to the worker in the future if they want to take it up. That has been, again, really controversial with the House of Lords, and it keeps trying to water it down to give workers the right to opt out of receiving those offers altogether if they just want to keep complete flexibility. But the government is standing firm on that one and again has been sending it back and has said, no, this is what we want to do. The other change for 0-hour contract workers is that employers are also going to be required to give reasonable notice of shift changes and compensate employees if they need to cancel shifts at short notice. So that's aimed to make sure that people aren't messed around too much by their employers if they're on casual contracts and they lose shift offers at the last minute. So our top tips in this area, first of all, it's going to be all about communicating with your workers and finding out what they want. But if there isn't a formal right to opt out, then this is a process which is you're going to have to go through as an employer every 12 weeks to make sure that you're complying with the obligation in this area. Knowing what your workforce is, who's on your books and what hours they are working is going to be absolutely key. So you need to have very clear documented records of the hours that those people are working in those periods so that you know exactly what you need to offer them and whether you can do that at the end of each 12-week reference period, and make sure that you budget for that. And if you can't make those guaranteed hours offers work, then you need to be thinking a bit more widely about potential restructuring or changing the way your workforce works. So those are our top tips, and back to Owen for the next change.
Thanks. The Employment Rights Bill contains lots of changes, lots of things that will be varied, but this is a brand new thing. So they are proposing the creation of a Fair Work Agency, and they're proposing this from April 26, which is incredibly tight timetable, and the cynic in me wonders whether that is doable, but that's what they're proposing anyway. I think their aspiration eventually will be for a Fair Work Agency to almost act like a police force on certain employment rights. It's going to be completely separate to the Employment Tribunal process. So employees will still be able to sue their employers for all sorts of different things. But I think the aspiration is that the Fair Work Agency is another place that people can go to complain about their employers. And whilst it is completely separate to the Employment Tribunal process, the intention is that the Fair Work Agency will be able to bring claims on behalf of employees. How that will work in practice, I don't know, we don't know, but that's what they're saying in any event. And the areas of jurisdiction that this employment law police force will be patrolling, certainly initially, are the ones on that third bullet point. So holiday pay, sick pay, national minimum wage issues, and you know, if there are any breaches of those, then your employees could bring a tribunal claim against you. But But this Fair Work Agency is almost like another looming entity that's going to be overlooking those sorts of breaches. And I mean, the national minimum wage keeps increasing, of course, and we're anticipating another increase in April. But the fiddly areas in which employers are sometimes caught short on the national minimum wage. I'm not paying an hourly rate that's less than the national living wage rate, but it's things like accounting for travel time or uniform cost or sleeping time and things like that. So those are just things to bear in mind with this new Fair Work Agency. Rachel, if you flick the slide. Another April 2026 change is the widening of the scope of SSP, statutory sick pay. So at the moment, you might be aware that for statutory sick pay purposes, an employee or even a worker, in fact, would need to have 3 holding days before SSP becomes payable from the 4th day of sickness absence. The proposal from April 26 is that they get rid of the 3 waiting days. So SSP will become payable from day 1 of sickness absence. And the second thing that is dramatically going to widen the scope of SSP is that the government will get rid of the lower earnings limit. So at the moment, an individual has to reach the lower earnings limit, which is £125 per week, in order to then become eligible for SSP. Now, by getting rid of that £125 per week lower earnings limit, it's estimated that 1.3 million people, 1.3 million employees or workers who currently earn below that earnings limit will now be within scope for SSP purposes. So that's quite a dramatic widening of the scope of SSP. And Rachel, if you flick the slide in terms of top tips for employers on this one, and of course we're looking at April 26 for this one, so not that long to go. We are advising employers to look at their sickness and absence policies, to look at whether you need to update those, look at whether you need to update your employment contracts as well, because often employment contracts will refer to 3 waiting days for SSP purposes. Look at your payroll and HR systems and the way they interact with SSP currently, and reassess your existing sick pay schemes. I mean, lots of employers pay better, more favourable sick pay entitlements than SSP, but lots of employers pay at the current rate of SSP. So you might want to crunch a few numbers and look at how this might potentially impact you from a financial perspective, at least. To you, Rachel.
Okay, thanks. So the next change is flexible working rights. So this is an existing right for employees in the UK. There were changes to it, I think, last year to bring more employees into line for making a flexible working request if they wanted to make it a day 1 right, and also to allow people to make 2 requests in each year rather than just 1. This right is now going to be strengthened further with the changes being proposed in the Employment Rights Bill. So as it stands at the moment, employees can make a flexible working request, and all that requires employers to do is to follow a certain process, which typically involves meeting with the employee, listening to what they've got to say, seeking to understand their reasons for making the request, considering it, and then making a decision. And employers have got the right to refuse a flexible working request after going through that process if they've got one of 8 statutory reasons. So the most common reasons for refusing a request would be inability to meet customer demand, too much cost, inability to restructure or recruit to cover the work that might be being lost if, for example, the employee is reducing their hours. If the employer can produce one of those reasons and it's gone through the process, then it is off the hook with that flexible working request. But the Employment Rights Bill will change that by introducing a reasonableness threshold, meaning that even if the employer has got one of those reasons, it will only be allowed to refuse that request if it is reasonable to do so in the circumstances. So that is going to involve basically more scrutiny of whether employers are being genuine and dealing with those requests reasonably and in good faith. At the moment, we don't really see tribunal claims being brought for a standalone breach of the flexible working regulations. This might mean more tribunal claims over this, and it may also feed into other claims for example, indirect sex discrimination or constructive unfair dismissal if employers don't act reasonably. But essentially, it will just make it harder for employers to refuse flexible working requests. It will put a bit more of a burden on them to do a proper exercise and engage their brains a bit over whether they genuinely need to refuse it and it's reasonable to do that. So I hope that makes sense. So just in terms of top tips in this area, have a look at your flexible working policy. You should all have one already because this is an existing right. It's just that it's going to be changed and strengthened. So make sure that your policy is up to date and it's reflective of the day one rights that people now have as of last year to make a flexible working request. And also make sure that your managers are trained on knowing what to do if a request is made. So in particular, they should be aware that a flexible working request, such as I'd like to reduce my hours or I'd like to work from home a certain number of days a week, they can't just make a decision off the cuff on that. They should be aware that that triggers a formal procedure. So they should go away and speak to HR or take advice and know what to do to handle that request properly. Okay, this next one is quite a big one and it's expected to come into force in October 2026, which again is not actually very long in employment law terms. So there's a limited amount of time now to prepare. So as it stands at the moment, fire and rehire, or also known as dismissal and re-engagement, is a fallback option that employers have if they are trying to restructure or change terms and conditions of employment. So a change to someone's contract of employment can only be made with the consent of both parties. So that should be done after a consultation process. So you should be talking to your workforce, you should be telling them what you're proposing to change, you should be taking their views and considering those properly and seeing whether you can reach an agreement with them on that change. That might be, for example, a change to shift patterns, a change to certain benefits, to holidays. It could be a change to pay or something like that. If it's a change to a contractual term, it requires agreement, is the general principle. At the moment, though, employers do have the option of, if ultimately they can't reach agreement, dismissing and offering re-engagement on the new terms. And that can be an important tool in employers' armoury if they've genuinely reached an impasse and they really, really need to make that change. Unfortunately, it's also quite widely misused by employers. So you might have heard, for example, about the P&O Ferries case about 4 years ago or so now, where P&O dismissed a huge number of workers and replaced them with agency workers on different terms because they just wanted to use that tool to change everyone's terms and pay everyone less. That's exactly the kind of thing that this change is looking to clamp down on. So what's being changed is that it's now going to become automatically unfair in law for dismissing somebody and rehiring them on worse terms and conditions, or replacing them with someone else in the same role but on worse terms and conditions. So that is going to completely take away employers' option to rely on or talk about relying on dismissal and re-engagement if they can't agree changes to contracts. The only exception to this is going to be where the employer can show that if it can't make the proposed change, it's genuinely going to go into severe financial difficulty, insolvency, then that is going to be allowed. But other than that, and that will be a high threshold, it's going to be automatically unfair in law. So it's going to give somebody a cut and dried unfair dismissal claim if the employer dismisses them because it wants to change their terms of employment and they don't agree to that. So that introduces a whole other category of unfair dismissal claim, which is why it's such a big change, and is going to make it more difficult for employers to negotiate over changes as well as actually making them. So some top tips now. I'm certainly not advocating for trying to rush through changes to T's and C's now. I'm not advocating embarking on dismissal and re-engagement processes now before the change comes in. That's certainly not what we're saying. But if you do foresee that you might have changes on the horizon that you would like to make at a certain point, or you might need to make at a certain point, it might be sensible to do a bit of an audit of that now and work out whether you genuinely need to go forward with that, and if so, whether you should do it before the Employment Rights Bill comes into force on this rather than after. More importantly, I would say, is it's important to look at your contracts of employment and make sure that they have got specific, what we call variation clauses in them. So a lot of contracts, particularly older ones, will have a general clause in there saying, we as the employer reserve the right to make any changes to your contract of employment on, say, a month's notice. That's not really enforceable because that's all subject to a reasonableness requirement, and you can't really rely on that as an employer. What you can rely on is specific variation clauses to, for example, make reasonable changes to somebody's place of work or their hours of work or certain other things. But to be able to do that, the clause needs to be drafted reasonably and it needs to be drafted very specifically. So if you don't have that in your contracts at the moment, you should seriously consider looking at those and introducing those clauses now, because you should still be able to rely on those clauses after this change comes into force. And the most important thing as well, I would say, is if you are considering trying to change your T's and C's, don't just do that blind, take advice, because that can be opening a real can of worms, and it does require you to act very carefully.
Thanks. I will run through family leave very quickly because it's a simple message, which is there's a widening and expansion of rights in certain areas. And it's a simple message for you as employers. It will be a case of updating your policies. So parental leave and paternity leave, in order to take them quickly, I'll do them together so that they will become day one rights. So there'll be a day one right to take parental leave, a day one right to take paternity leave. The third one, this is a bit indicative of things relating to the Employment Rights Bill. We don't actually know what that's going to look like. So this concept of strengthening protection against dismissal for those who are pregnant or on maternity leave or having returned from statutory family leave. We don't really know what that looks like yet. There's speculation that it might be similar to the current protection again in redundancy situations for those who are pregnant or on maternity leave, where they have priority over suitable alternative employment. It might be along those lines, but related to some sort of dismissal. But we're light on detail on that particular one. We are more clear on number 4, bereavement leave. So the intention is to extend the current right. So there's a current right in law to 2 weeks unpaid statutory parental bereavement leave, but parental being the key issue at play there. The intention is to expand that to be more of a general statutory bereavement leave right for those who not just have lost a child or somebody who they have parental responsibility over, but those who lose close family members or dependents. And again, that is expected to be a day one right. So the common theme here is a widening, a subtle expansion of certain rights, and your policies, your policies in your staff handbook should be updated to reflect the new position on these. And by the way, all of these, we're expecting them in April 26, which is a bit alarming on number 3, given we don't exactly know what it looks like. But in terms of 1, 2, and 4, we know exactly what that means. And employment policies we're advising should be updated in readiness for April 26. The next one, Rachel, if you can flick the slide, protections against harassment. So the first one is a big one. There will be a new duty for employers to prevent harassment from third parties. So you as an employer will be expected to prevent any harassment being caused to your employees by your contractors, your customers, your clients, your suppliers, third parties that your employees might engage with. That is quite a big deal. I'll tell you more on the next slide of how I suggest you go about thinking about that in a practical sense. And the second box there, you might recall a year ago, just over a year ago, in April 24, the government introduced a positive duty on employers to prevent or to take reasonable steps to prevent sexual harassment in their workplaces. This second box intends to add one little word to that duty. It's a one little word, but one big implication, and it's the word all. So from October 26, which is where all of that and the third party harassment duty is proposed to come into play. From October 26, so less than a year from now, employers will be expected to take all reasonable steps to prevent sexual harassment in their workplaces. We are awaiting Equality and Human Rights Commission guidance on what the word all might mean for employers, but I'll give you a bit of an idea on the next slide of what I think it might mean. Very, very quickly, these are less commonly arising issues, but there are some changes around NDAs in the context of harassment, discrimination, and also complaining about sexual harassment will become an act of whistleblowing from April 26th. They probably come into your world less often than the first two boxes. Our top tips for employers in terms of third-party harassment, you might want to review, and this is less employment law advice actually, and more commercial law advice. You might want to review your contracts and T's and C's with third parties, because you might want to pass on some responsibility and expectation on your customers, on your clients, on your suppliers, on your contractors, to actually look to take steps themselves to prevent harassment. You might want to indemnify yourself against certain claims for harassment arising from what third parties employees do. You might want to have a look at that. And then other than that, in terms of that addition of the word all and your expectation from, we expect October 26th to take all reasonable steps to prevent sexual harassment in the workplace. It's a new duty, but it's a very old-fashioned solution. And the old-fashioned solution will be the age-old trusted policies and training on those policies. So you should, as of the introduction of the duty in 24, have better sexual harassment policies with reporting lines and expectations. If you haven't, then I would advise you to look at that. And then the next advice we would always give employers is to train on those policies. So have better, improved policies and train all staff on those policies and train them on a regular basis. Back to you, Rachel.
Okay, just a couple of changes to go now, and I'm conscious of time, which is absolutely flown. So the penultimate change is relating to the Employment Tribunal process, and specifically the time limits that people have for bringing a claim. At the moment, everybody has, or for the vast majority of Employment Tribunal claims, you have 3 months from the act complained of, whether that's dismissal or an act of discrimination or whistleblowing or something like that. You've got 3 months to kick off the process by contacting ACAS to tell them about your claim, and then after that by going to the Employment Tribunal. So contacting ACAS is the first thing you need to do, and you've got to do that within a 3-month period. That is going to be increased, that's actually going to be doubled to 6 months for almost all types of claims. So there's one exception on the slide there. And that, although it sounds more of a procedural issue, could be a huge change and will greatly affect us as employment lawyers, but will affect employers and what they need to do in terms of things like record keeping requirements and retention in particular. So 3 months to 6 months is going to bring into scope a lot of people who have waited around and weren't sure whether they wanted to do something about, for example, an act of discrimination or a complaint of discrimination or a dismissal. And that includes something that's happened during the course of their employment, not just dismissals. So the normal position is you've got 3 months to do something about that, or you're out of time. Changing that to 6 is going to be a huge change. It's going to massively increase the number of Employment Tribunal claims, we think, that we will see. And it also is combined with a change which you might have heard about last week, which is a change to the ACAS early conciliation process itself. So at the moment, that process lasts for a set period of 6 weeks, during which an ACAS conciliator will talk to the employee, they'll talk to the employer, they'll see whether there's a deal to be done. If that doesn't happen, the 6 weeks come to an end, and the employee then has to decide whether they want to go to the Employment Tribunal or not. As of the 1st of December this year, and it's important to say this was only announced a couple of weeks ago, so this is being massively rushed through. As of the 1st of December, that 6-week period is also being doubled to 12 weeks. And during that 12-week period, the clock, the time limit, 3-month time limit for employees to bring claims is frozen. So if you add that 12-week period to the new 6-month period that people will have to start the process, that is going to mean that people have around 9 months or sometimes even a little bit more before they actually have to take a claim to the Employment Tribunal against their employer. So if you're an employer, that unfortunately means a huge amount of uncertainty, because you might not know until maybe up to a year later. You might not be sent a copy of the claim by the tribunal in the post. And so by that time, obviously, memories will have faded, witnesses might have left the business, records might have been deleted, and so it might be much more difficult for you to defend that claim. So that means the retention of records is going to be really important. You might want to review your employee privacy notices or data protection policies to make sure that you retain records for a long enough period. And that includes records relating to job applications as well as actual employment, because job applicants have the right to bring certain types of employment tribunal claims as well, such as for discrimination. And you might also want to make sure that you have a really comprehensive exit interview process and you keep proper records around the reasons for dismissal, any disputes around dismissal and things like that, just in case you get a late stage claim at a later date. One other thing to say on this is that although I'm not going to spend any time complaining about the state of the Employment Tribunal process, it is a very difficult process for people to navigate at the moment, because the tribunals are already overwhelmed by the number of claims that they're facing. So that's very difficult for people bringing claims, it's difficult for people defending claims, and obviously for those working within the system as well. These changes and the other changes that we've talked about in this session will inevitably make that situation worse, unfortunately. So it is going to be a long and slow process for those who do have to go through it. I hope that doesn't apply to anyone on this call, but as employment lawyers, we're always having to be realistic with people about how long it can take for these disputes to resolve themselves from start to finish. Finally then, and very, very quickly, oh sorry, that slide has moved over to the left a bit, but I'll just tell you what it says. So trade unions, there are various changes that are being brought in from October 2026 onwards relating to trade union rights, which will in particular strengthen unions' rights and recognition in workplaces. So first of all, there will be greater access rights for trade unions to go into workplaces to try and recruit and represent themselves in those places. There'll be an improved recognition process for them, so it will be easier for them to gain statutory recognition by employers. There will be stronger protection for those employees who are union members, to be protected against detriment or dismissal as a result if they need to carry out their trade union activities. And this last one is probably something which will affect more employers than any of the others. All employers will be obliged to tell employees from day one of their employment that they have the right to join a trade union. So at the moment, there's certain information that has to be given to people from day one in a contract of employment or another document about what their terms and conditions of employment are and what their rights are. This is going to be added to that list. So everyone will have to be told from day one, and also, we think, reminded regularly that they do have the right to join a trade union if they want to. So that wraps things up, and as Owen said, that was a real whistle-stop tour of very many changes that are happening, but just to give you a very quick summary of our top tips in general on all of these. First of all, this is a fast-moving area. There are still arguments happening in Parliament about what exactly the letter of these changes is going to be, so please keep on top of that, and we do have some quite tight deadlines for some of these changes in particular, so you can't take your eye off the ball on all of these, and we certainly can't as employment lawyers either. There are, though, consultation processes happening on some of these things, which will be going on next year and into 2027. So some of these things could still be subject to change and won't happen until a little bit later. If you want to participate in or contribute to those consultation processes, you can do so as members of the public, so have a look out for those. Prepare yourselves now. Some changes are happening now. We've already talked about things like changes to NDAs, the changes coming into SSP in April, for example. You need to prepare yourselves now for those. So don't rest on your laurels. Have a look now at what you need to do. And I think in general, the biggest thing that you can do is have a look at your written documentation, your policies and procedures, and make sure that your managers are trained up on employment practices and HR practices in general, because that will set you up well for what's to come in the future, whatever that looks like. So that was our summary, and I'm going to hand back over to Tom now to wrap up and to oversee any questions that we might have. But thank you very, very much for listening, and we hope that's been helpful.
Brilliant. Thank you very much, Owen and Rachel. That session was really informative. I think one of the questions that did come through, Owen's already jumped in the chat and asked that as well. So thank you from Lucy. Thank you for coming along. Hope you found it really helpful. We will leave the details and we will send them in the resources email that we follow on this session with. So you'll be able to reach out to Owen and Rachel if you have any questions that you didn't want to ask right now. We've also, if there are no other questions, there's a few other updates. We've got more events coming, more people stuff. The last one of the year on the 2nd of December is our festive reset for people. A really nice way to help de-stress and go into December feeling calm rather than feeling frantic. We've already planned the whole of 2026. So starting on the 13th of January, we're looking at workplace isolation and loneliness for people. On the 13th, I've put all the links in the chat as well. There's also in February we'll be jumping onto self-sabotage, which is an interesting topic that a lot of people have asked for as well. And you'll also be able to join the LinkedIn group that we have there as well, People Network. It's free for everybody, and we share updates, replays, and plenty of resources so you can join in the conversation. So if nobody has any questions, I don't think so. So thank you, Rachel and Owen. It's been great to have you and to share your wisdom and knowledge. And thank you for delivering a session that is offering great value to the People Network.
Thank you so much for having us, Tom.
Thanks for the opportunity.
Thanks, everyone.
Thank you, everyone, for coming. I'm going to be ending the event now.